Hi there, this is Bob Davie with San Diego Residential Property Management, and it's great to be coming to you again from our headquarters here in my den at my home in San Diego. And I'm thrilled to be joined today by a good dear friend of mine, Jim Roth, who is a practicing attorney here in the state of California, happens to be my business attorney, as well as in a unique situation, he's also a client of mine. And so Jim has agreed to accept my invitation to assist us here as we go through the next few minutes of just answering some legal update type of questions. Over the course of the last, probably 3 weeks or so, primarily, I've received a number of telephone calls, emails, text messages from my clients, just wondering, in the midst of this global pandemic, what are my options? What are my legal options? What's my recourse if my tenants don't pay rent? And just a ton of different questions. And so I thought that it would be a great opportunity to, first of all, introduce you all to Jim and give Jim an opportunity to have the floor to answer some of these common legal questions. But before we turn it over to Jim, I also just want to let you know that I will have his contact information available to you when this goes out to you on your owner portal. We'll have his email address available to you that you can reach out to him directly if you have follow-up questions of him. And I would encourage you to do that. But thank you, Jim. Thanks for joining us. I really appreciate your time and expertise.
Thanks, Bob. Thanks for inviting me. I'd like to start by placing our conversation in perspective. So today we're going to talk briefly and provide an overview in general terms. And so what we're talking about is not intended to be a complete summary of the complex legal issues regarding evictions and how the current laws are affecting our landlord-tenant rights and remedies. So I recommend to all of our listeners that for your particular issues and concerns, please reach out to your attorney, talk to them so that you can get the most accurate, up-to-date legal advice. What I hope to accomplish with you today, Bob, is to raise questions and thoughts for the landlord listeners that will watch this and come up with some intelligent questions to take back to their attorneys so that they can best protect their rights and remedies.
Perfect. And again, we really appreciate your willingness to help us out here on some of these tough issues. And I think the first thing that I wanted to be able to bring up is maybe to ask you, as best you can in as short a period of time as possible, take this 400-page document called the CARES Act and kind of summarize it for us in terms of the bullet points that might affect landlords the most.
Great place to start, Bob. Thanks. So on March 27, 2020, Congress passed the Coronavirus Aid, Relief, and Economic Security Act. We call it by its acronym, the CARES Act. Section 4024 of the CARES Act provides a qualified temporary moratorium on eviction filings as well as other protections for the tenants. The qualifier here is that the landlord's mortgage, if there is a mortgage on that property, must be owned or securitized by a federal agency such as the FHA, the VA, Fannie Mae, or Freddie Mac, or that the mortgage must be insured, guaranteed, or otherwise assisted by federal government agencies. So here, for purposes of our discussion, the CARES Act prohibits landlords from initiating eviction proceedings or charging fees, penalties, or other charges against a tenant for the non-payment of rent. These protections extend for 120 days from the date of inception, which was March 27, 2020. From the CARES Act, drilling it down a bit, on that same day, March 27, 2020, Governor Newsom here in California issued an executive order which established a statewide moratorium on evictions. Governor Newsom's order differs somewhat from the CARES Act in the following. Under Governor Newsom's order, it prohibits the enforcement of existing evictions in place through May 31st, 2020 for any renters that are affected by COVID-19. It also prohibits landlords from beginning the eviction process through unlawful detainer, and it prohibits courts from enforcing any type of successful unlawful detainer action. So to qualify as a tenant under Governor Newsom's order, the tenants are required to declare in writing no more than 7 days after the rent is due to the landlord that the tenant cannot pay all or part of the rent because of COVID-19. So one of the requirements under Governor Newsom's order is that the tenant would be required to retain certain documentation that proves that they have the economic inability to pay, but they're not required to produce any such documentation to the landlord. They simply have to write to the landlord saying, I'm unable to pay because of COVID-19. So that, in my view, is a recipe for fraud. We'll discuss that in just a little bit. Now, having said that, the last point I want to drill down is the city of San Diego. So we've started on the very broad CARES Act. We've gone to the state of California. City of San Diego also passed a moratorium on evictions. What's interesting for the city, and this is only for landlords who own property in the city of San Diego proper, is that the tenant has to produce documented, verifiable evidence that they are unable to pay because of economic impact from COVID-19. And the city of San Diego, in fact, has identified what types of documentation is required, such as a note or a letter from an employer, payroll records from an employer, bank statements, medical records and receipts. So what my best advice is to the landlord, while you may be susceptible to having to suspend the rent for a term of office, it's important that you get documentation from the tenant that is objectively, independently verifiable, but not harassing to the tenant to prove that they are adversely affected economically by COVID-19.
Interesting drill down there, going from the federal to the state to the local level, Jim.
And that local level, Bob, also would apply to other cities, but this isn't the time or the forum. You probably don't want to hear me talk about every municipality in the county of San Diego, but every municipality pretty much has something in place, and our listeners, to the extent that they have properties in any of these municipalities, should check what the local laws are as well.
For sure, and I appreciate that, because there are, as we all know, a number of municipalities, and many of them follow the lead of San Diego City, although they're not obviously required to do that. You've got the city of El Cajon, city of La Mesa, Del Mar, so on and so forth, and there are a lot of different municipalities, but so many of them do follow the ordinances and legislative lead, if you will, that the city of San Diego provides. A couple of follow-up questions here that I can think of off the top of my head. And again, I'm kind of placing myself in the role of a property owner that's listening to us when I ask this question. It sounds to me as if the CARES Act only applies in the event that I have federal funds that are securing the mortgage on my property, rather than, say, private money loan, or let's say I own my home outright and don't even have a mortgage on it. Then am I correct in assuming, and I don't want to assume, but am I correct in assuming the CARES Act in and of itself in those cases do not apply to me?
That's correct. It doesn't apply. You have to be holding a mortgage that somehow is federally issued or guaranteed.
Got it.
Private mortgage, nope, not subject to the CARES Act, but subject to Governor Newsom's executive order, and then also subject to whatever local municipality regulations have recently been passed.
Okay. And then I guess the other question, and you may be going into this somewhat either in this presentation or perhaps even future presentations, but one of the questions that I've had recently that is really kind of compelling and somewhat interesting is not actually related specifically to eviction. It's mostly related to notices, and termination of tenancies as an example. So one of the questions that's come up, for example, is if I've got a tenant of mine that is actually just naturally terming out of their lease agreement, say June 30th. I'm just kind of making this up as I go, but let's say it's June 30th. And I definitely do not want them to renew. let's just say. Under normal non-COVID-19 processing, we would be providing that tenant with either a 30 or 60 day, minimum 30 or 60 day notice of termination of tenancies. Is something like that still doable during the middle of the COVID-19 pandemic? Are notices even being considered at this point?
Well, that's an interesting question. So if the tenancy is naturally terminating, then it would not be an eviction process or proceeding. However, for example, CARES Act adds an additional 30 days to notice requirements if you're subject to the CARES Act. Governor Newsom also has some additional time. City of San Diego additionally has some time that extends the opportunity for the tenant to respond. My understanding of the purpose of the temporal extensions beyond what the statutes already provide is to allow a tenant, if they are unemployed, to get unemployment benefits and be able to start developing the funds to either renew the relationship with the existing landlord or go somewhere else and still have a stream of income. So the whole mindset behind this is those that have been adversely affected, such as the service workers, the people that work in the restaurants, the dry cleaners, the bars, the people that may live more check to check than other people. The whole purpose of this is not to put them out on the street, to be able to come up with a fair and compassionate solution. Importantly, and what we'll talk about shortly, is this provision for evictions. While you can't evict because the tenant stops paying rent, there's nothing in the law that says that the rent is forgiven. The tenant is still responsible legally under the terms and conditions of the operative rental agreement. We'll talk about that in a few minutes.
Okay, well, thank you. Thank you for catching that question on the fly. I appreciate it. So let's jump to a burning question that a lot of people have, and that is really, the heart, breadth, and depth probably of what this little video email is all about, and that is, do my tenants have the right to not pay rent?
No, they don't have the right to not pay rent in the sense that I'm interpreting it. So let me clarify that. So both the CARES Act and Governor Newsom's order issues a statewide prohibition on evicting tenants who don't pay rent because of economic circumstances resulting from COVID-19. Under the CARES Act, it says that the tenants are not released from the rental payment obligations. It simply says that the landlord cannot evict because of the non-payment. Under Governor Newsom's order, it notes that tenants remain obligated to repay the full rent in a timely manner. So there's currently no laws in effect that say that the rent is forgiven, which then dovetails to, well, we hear commonly threats of rent strikes.
Yes.
A rent strike would be when two or more people say we are not paying rent because we are an adversely affected group of people and we're not paying rent. They can do that, but that doesn't mean that they get to legally do it. So they're not forgiven for the rent. And if you willfully withhold rent and you don't satisfy, either you, the landlord, or the tenant fails to satisfy the requirements for the non-eviction procedures, you can begin procedures to evict a tenant. Now, having said that, let me point out two proposed bills that are sitting in the California legislature, and they're coming in from both ends, one in favor of the landlords, one in favor of the tenants. The pro-tenant bill coming out of the state assembly is referred to as AB 828. And 828 would force every landlord in California to reduce rents by 25% and also force landlords to subsidize the rents of their tenants. So it, in and of itself, provides no assurances that landlords can collect rent, remove problem tenants, or get a fair hearing in a court system. Separate and apart from that is a Senate bill, and that is SB 1410. And SB 1410 would make direct rental payments to landlords to help tenants who can't afford to make those rental payments because of the economic impact and effect of COVID-19. 1410 would cover at least 80% of unpaid rent attributable to the pandemic. Landlords who agree to participate and accept that rental payment subsidized by the state would also have to agree to three things. One, they would not increase rents for a specified period of time. Two, they would not charge late fees for any of the past due rent paid by the program, inferring they could charge late fees for past due rents not paid by the program. And three, the landlords cannot pursue any remaining rent owed for the months paid by the program. So for instance, if this passes and let's say it's going to pay 80%, then the landlord has to walk away from the other 20% in return for the guaranteed payment of the 80%. Currently, they're tracking through the legislation. There's no idea. My crystal ball doesn't tell me if it's going to pass. What does your crystal ball say for either one or both of those?
Again, I agree with you. None of us have a crystal ball. And the purpose of this is to really educate and to make people aware of the fact that those measures are out there. They physically exist. And I think in either case, we're all up the creek without a paddle to some extent. I think you mentioned something earlier, though, that really resonated with me, and that is a couple of things. Number one is no one at this point in time would gain advantage by having a property that is vacant.
Yeah.
Period. That doesn't help anybody. It doesn't help the tenant. It doesn't help the property owner. And there are a lot of other complexities that go along with having a vacant property, that's for sure. And so I think it's in everyone's best interest to, work together throughout this entire issue. And these bills, although I don't see the first one, which is the 828, Assembly Bill 828, I just don't see that passing. I don't see how it possibly can pass. And the reason for that, and Jim, you and I were talking about this earlier, is it opens up Pandora's box. If I'm doing rent, forgiveness, well, now what about mortgage forgiveness? What about car payment forgiveness? What about, I owe my dentist, $2,000 for a crown that I had put in, and on and on and on it goes. It's a slippery slope that I just don't see how it could possibly gain any traction. The SB 1410 could be something that we actually see. And by the way, SB 1410, for the purpose of our conversation and our listeners, need to know that that's a bill that's sponsored actually by the California Association of Realtors as a way in which it can answer, if you will, rather than AB 828, where it's just complete forgiveness of rent. At least, the SB 1410 provides with that 80% of the rental income for at least a defined period of time. So that may get some traction, but stay tuned, and we'll be able to have more information. Probably, I would think within the next month or so, we'll have a little bit more information coming down to us from Sacramento on both of those bills.
Yeah, I agree with your take.
Let's segue to the next question that I have been getting again from clients over the course of the last several weeks. What, in the event that my tenant does not pay rent, or a portion of that rent, let's just say also, what are the options that are available to me moving forward?
Good question. One that we've talked about and hashed before we did this. So landlords, as you just pointed out, are affected by rent suspension. They may find themselves, the landlords, unable to pay their mortgages on the property, their property managers like you, their maintenance costs. There will be a cascading effect of dominoes. And so we know that the CARES Act provides relief programs for government assistance to help mitigate missed rent payments. And while this is a lengthy topic and one that we're not going to take a deep dive into now, let me touch it from the superficial approach. So landlords may be eligible for CARES Act rent abatement and suspension and the landlords would in turn be able to take advantage from CARES of mortgage abatement and suspension. And so there is mortgage forbearance programs available by the CARES Act. Well, I don't want to go into details with that, and you did a very good job last week setting the tone for that. I want to bring a couple legal thoughts to this so that the listener can hopefully gather more facts to make an informed decision as to whether this is something that they want to pursue. So forbearance is when a lender allows you to suspend making your monthly mortgage payments. It doesn't forgive it. It doesn't wipe it off the books. It just suspends it. Forbearance does not erase what you owe, so you, the landlord, will still have to be responsible for repaying the missed payments. And here's where it gets a little slippery. So if you're able to stay up with your payments, I strongly suggest that our listeners do so, because if you have to reach out to the lender has a variety of different mechanisms available. For instance, I've seen programs where the lender will suspend the rent for, say, 6 months. On the 7th month, you have to repay as a balloon the 6 months of missed payments of principal and interest, and you have to make that 7th month payment. Well, that's not very helpful, because that undermines the whole purpose of trying to get a forbearance on this. Other programs will allow the landlord to amortize it. So let's say I suspend 6 payments. I may make 1 extra payment for the next 6 years, so I'll make 13 payments a year for 6. And there are a number of different things in between those two extremes. Or you do it as a balloon addition at the end of your final payment for the life of the loan. Bottom line is that every lender has different rules and regulations, so it's something that I strongly suggest any landlord who's in economic duress through this look into. But be careful what you say that you're going to do, because this could come back and undermine the whole purpose altogether.
Well, yeah, and neither of us are qualified tax accountants either, but I'm assuming that whichever decision a particular property owner would make would also have very specified tax implications potentially to them as well, which they need to take into consideration as they go through their due diligence on trying to determine, what is the best single path that I would want to take.
Right, and that's a very good point. Any decisions that the landlords make here should involve their CPA and their attorney to give them guidance so that the landlord can make an informed decision.
For sure, okay.
So the other thing that is also an option available are proceeding with the unlawful detainer actions. And it's a good and bad thing. And we talked about it a few minutes later, so let me pick up where I left off. So landlords may arguably proceed with eviction process, what we call unlawful detainer actions, under any of the following. First, if the tenant fails to timely provide documentation or independently verifiable information that they're unable to pay because of the economic circumstances. Secondly, if the landlord's mortgage is not federally owned and they're not subject to CARES. 3, if the landlord has no mortgage on the rental property. Or 4, after the termination of the moratoriums, whether it's the CARE moratorium, the suspension, the state of California, the city of San Diego, or whatever jurisdiction. Now that sounds all very good, that the landlord has a limited window that they can't do anything on the next business day they can. Unfortunately, on April 6, 2020 of this year, the Judicial Council, which is the leading organization that operates and controls the court system of California, passed a rule. It was an emergency rule, and among the components of the emergency rule was to suspend all eviction proceedings statewide. Now, this does not apply to evictions necessary to protect health and safety. So if you have tenants that are using their habitable place to use as a meth lab, you can evict them. If they're committing a crime, if they're violating something that affects health, safety, and welfare, you can evict them, and the courts will be there for you. But if it's not that, you can't evict them. The suspension is applicable to all courts in current orders in which a judgment and order has been achieved to proceed in evicting the tenant that you've won, the unlawful detainer. It's now suspended. You can't enforce it. You can't file, you can't prosecute, you can't enforce. And here's the problem that I have. This new rule will apply until 90 days after the governor lifts the state of emergency related to the COVID-19 pandemic, or until that rule is amended or repealed by the Judicial Council. So currently, as we sit here today, Bob, we have no idea when that date is going to occur, which means until that date occurs, the court system will not entertain any eviction proceedings.
So what I hear you saying
yeah,
yeah, right. What I hear you saying is there is effectively no end date to this particular mandate.
There is currently no end date in state court. Having said that, there are certain limited qualifications which may allow you to prosecute a claim in federal court. If you can get into federal court, one of the things that you must satisfy at the beginning is what we call diversity. Diversity of jurisdiction, which means the landlord cannot be the citizen of the same state of the tenant. So to the extent that any of our viewers are maybe located in Nevada and own a property here, they may be able to bring a federal or bring an action in federal court, which would not be subject to this suspension by the California state court system. But that's going to be just a small group of people.
Yeah, yeah. Well, let's hope it's a small group because, here we are, we're approaching a May 1 rental due date. And as everyone knows, like even with my last video email that went out, none of us have a crystal ball. We have no idea exactly what to expect. But I think where we were going is it's in all of our best interests to be compassionate, be aware of what our options are, which is why we're producing this for everyone today. But another question, or the final question that comes out that's related to all of this is, let's pretend for a moment, Jim, you're a client of mine, and let's pretend for a moment that we get a telephone call from your tenant, or a letter or an email from your tenant that basically says what you've indicated, because of COVID-19, I'm unable to pay all or a portion of my rent, let's just say. I'm assuming that you're in the same camp with me in that it's really in our best interest to do what we can to work through this particular situation with that tenant. In your estimation, what are some possible, what we would call workout plans that we might want to deploy within certain guidelines, of course, but what would we want to deploy on behalf of that landlord that's dependent upon that income, as well as, of course, that tenant who finds themselves really in a sticky wicket, as they say, with regard to being able to actually come clean and pay their rent.
I am in the same camp with you. I agree that what we are experiencing worldwide is something that you and I have never been confronted with before. And it's not us against them. It is a sense of we're all in this together. And there's more commonality than not. And so the first thing I recommend is I view the relationship that I have as a landlord with my tenants as a partnership. And as a partnership, if I have not done so already, I should be getting on the phone and calling my tenant and making sure that they're safe, that they're healthy, that they're in an environment where they feel safe and healthy. I think that a stream of communication is far more productive than simply pointing the finger and saying, you do this or that. So my first recommendation is reach out and talk to your tenant. And it could be you as my property manager, Bob. It could be you and me conference calling with the tenant. It could be you and me separately reaching out. But I want my tenant to know that I'm concerned about them and that this is bigger than everything. The next part of that conversation, after I make sure that they're healthy and safe, is where do we go from here? Do you have the ability to continue making the rent payments? If not, then we should start a dialogue. How do we solve this problem? Because the rent strike's not going to work. The rent forgiveness only works if I'm in a position where I have the luxury of offering a rent forgiveness. If I'm not needing the rent payment as a landlord to make my payments to service that property, I may be able to entertain some rent forgiveness. Other than that, it's the ability to work out an agreement, and the key term is repayment. And certainly I would want the tenant, if they're asking for some kind of suspensions, the tolling of the rent, the forbearance of the rent, I need to know why you can't pay. I need something independently verifiable and objective. A letter from your employer would work just fine. Now, it doesn't mean that fraud can't happen, because certainly there will be people that take care of that fraud aspect. But I'm assuming that my tenants and all the other tenants are good and decent people. And so being able to come up with a written agreement that talks about repayment terms, going into the agreement with flexibility, knowing that even though we agree that we're going to suspend your rent for 4 months, and on month 5, you'll begin paying back an extra $100 a month until it's paid in full with no interest on that, or whatever terms. I have to go into it as a landlord knowing that's good today, but there's no guarantee that the tenant's going to have the wherewithal, that they're going to have the job, the stream of income, the liquidity to do that. So as a landlord, I strongly urge you to go into this with flexibility. Be a partner with your tenant. If you haven't already done so, recommend to your tenant that they may be able to tap into CARES. There are certain aspects of CARES that cover all kinds of different types of payments that you may qualify for. Same thing in the state of California for unemployment. There are all kinds of special programs now in place that you may be able to get some supplemental money, even if you're working. If you're not working full-time, you may qualify. So as a landlord, I want to do what I can to maybe help you, and see if we can tap into some sources. At the same time, landlord needs to be communicating, if necessary, with the lender of the property to keep them in the loop, to find out what, if anything, that particular lender is offering to individuals such as the landlord. What is available? What can you tap into? You may not have to pull that trigger, but you want to know what your options are going into it. So again, the more information that you can get now as the landlord from both the side of dealing with your lender and with dealing with your tenants, the more you can make informed decisions moving forward.
Wow, well put. Very, very well put. I appreciate all of that input and comments. And Jim, I appreciate, again, you taking the time out of your busy schedule to be able to answer these really need to know questions as this highly dynamic, fluid environment in which we're all participating in, is a part of our lives. So I again, thank you very much for being here and answering these questions. And to my clients, I want to say, I hope that you found that this was exceptionally valuable. And in the meantime, please know that we may be able to be in a position as time goes on to provide additional video emails that come out with other topics as well. Jim has agreed to be able to, on an as-needed basis, provide guidance to all of us. And as I mentioned from the very beginning of this email, I will be providing each of you with Jim's contact information so that if you have follow-up questions that you'd like to have him answer on a one-by-one basis, he'd be very happy to help you with those. All right?
Absolutely, Bob. Yeah, thanks for this opportunity, Bob.
Of course, and have a great rest of your day, everyone, and take care, stay safe, and stay connected. Thank you.
Bye.